Hello, government students. This is a lecture on the judicial branch that will be part of Learning Module 8. Here are the objectives that I hope you'll be able to accomplish at the completion of this learning module. Article 3 establishes the judicial branch of our national government. And so we're going to begin our discussion of the judicial branch by looking at Article 1 and what it provides. The very first sentence of Article 3 reads that the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as Congress may from time to time ordain and establish. So let's take that for just a second. Article 3 only establishes one court for our federal court system, the one we call even today the Supreme Court. So when you're reading through the Constitution, you're probably only going to ever see it referring to the U.S. Supreme Court, but that's only because that's the only court that existed when the Constitution was initially written. But you'll see here that the Constitution gives an enumerated power to Congress to set up what is called inferior courts. And that's just a reference to the courts that sit in the federal court system beneath the U.S. Supreme Court. And when I say beneath, I just mean in the terms of kind of the hierarchy of the court system. And I'll elaborate on that hierarchy in a little bit. But I just wanted you to notice that all the Constitution really establishes at the get-go is one Supreme Court. It's just giving Congress the authority and power to set up the rest of the court system, which it did. The very first Congress of the United States under the U.S. Constitution passed a series of judiciary acts, and that legislation created this, a pyramid or a federal court system. Now, what you see in this graphic presents the federal court system as it exists today. Now, in 1787, our population was smaller, our country was smaller, so it would have looked a little different. But it still had this same hierarchy. The U.S. Supreme Court was established specifically by the Constitution. It was formed by the Constitution. Congress also formed circuit courts of appeal that sit under the U.S. Supreme Court in terms of power. And then the U.S. district courts were formed also by these judiciary acts to serve as the courts of original jurisdiction where cases would initially be brought in the federal court system. So I'll elaborate on the powers of those courts, but first I just wanted you to see exactly how the structure is set up. You had that one Supreme Court that the Constitution formed, and then these others that Congress formed later. Okay, so as we go through the court system, I'm going to start out with kind of a rather detailed explanation for how federal judges are selected. And I'm just going to give you a little bit of warning that what I'm about to tell you may not be in your textbook. I'm going to supplement here with things because I have a background as a lawyer. I have some experience with this that I'm going to add to our study of the judicial branch. And then again, in our studies of civil liberties, I'm going to be throwing in things that I've learned through my career. So you definitely want to be careful to take notes on these lectures because you may not be able to find this information in your textbook. A lot of it's there, but just in case, make notes of what I'm saying. So how are federal judges selected? Well, you start with Article 2, actually. This isn't directly in Article 3. The selection process, that power to select federal judges is given to the president and the Senate as well in a confirmation role. So, unlike the other two branches of government, federal judges are not elected to their job. The voters don't choose judges, at least not at the federal court system. Often they do elect judges in state courts, but not the federal court. In the federal court, the president nominates a judge and then the Senate approves the judges. So it's a different arrangement, something that's unique to our judicial branch. And so let's look at that process then in more detail. Um, First of all, it involves not just the U.S. Supreme Court, it involves all federal judges. So we aren't just dealing with the 9 justices of the U.S. Supreme Court. Those are the ones that you hear the most about. But we're all federal judges across all three of those levels in the pyramid. All of them have been nominated by the president and then confirmed by the Senate. It is a very, very long journey to even get to the point of being a nominee. Um, you start out as a lawyer. So to become a lawyer, you first must go to college. Many of you may be on this path, by the way. You never know. But if you're studying now in college here at Lander and you're looking at law school, you're already on the track to becoming a member of the federal court system. So first you go to college. You do well in college, you graduate, and then you would have to take an exam to be admitted to law school. That exam is called the LSAT. And I don't remember what LSAT stands for, but it is a specialized exam just for law school admission. If you score high enough on the LSAT, you will get admitted to a good law school, and you study in law school for 3 years, studying the law, studying legal ethics. And then you graduate from law school, and in order to actually practice law, you have to take another exam. It's called a bar exam. And that exam tests your competence and understanding of the law, of the substantive law, like contract law, tax law, property law, criminal law. It's testing your understanding of all the different areas of law. And each state has its own bar exam. Unfortunately, there is no national bar exam, although in my humble opinion, there should be. It would be a lot easier. Anyway, it's not true. You just have to take them in a state. So every state has its own bar association, and that bar association regulates the admission of attorneys to the practice of law in their state by giving this very difficult exam that lasts 3 long days. It's a very intense process, and it's a very difficult exam itself substantively. But if you pass the bar, then you have to go and take an ethics exam. So yet another exam that is judging your understanding of ethics, of right and wrong, and what good practices, what are ethical practices in the area of law and practicing law. And even as a judge, there are judicial ethics that govern the practice of being a judge. So if you pass the ethics exam and you pass the bar exam, you will be admitted to a state bar association and given a license to go to court and practice law in your state. But it doesn't end there. You must continue studying law. You must do what's called continuing legal education. In order to maintain your license, you have to continue taking classes on the law, learning the law, and learning how it applies in specific situations. You're required to do it on an annual basis. You have to prove that you've done it, show the bar that you've taken these courses and completed the requirements for continuing legal education. You must also maintain a good reputation as a lawyer. You must be known to your peers as a good lawyer, as an ethical lawyer, and become known also to, if you're looking to become a judge, you must become known to the politicians in your state, because politics, unfortunately, plays a role in this process of becoming a judge. So judicial experience plays a role as well. If you become known to the senators in your state, then you will get on a short list of potential nominees. If a vacancy occurs in your state, you could potentially be nominated. But again, you have to sort of be known by politicians in your state to have this good reputation in the bar, to have passed all these exams. That is a long, long journey to even the point of becoming a nominee. But if a vacancy does occur in your state on one of the federal courts, then you might get on a short list of potential nominees that is maintained by the senators of your state. So the the job of nominating someone to the court is that of the president. The president makes the nomination, but he doesn't do it alone. He'll consult the senators of the state in which the vacancy exists, ask them for their short list. They give their short list to him. Then he asks the FBI to investigate the men and women on this short list. So the FBI investigation takes some time. And then the president looks at the results of that investigation and chooses the nominee from this short list. Then the president makes his nomination known to the public. If it's a job on the U.S. Supreme Court, it's probably going to be announced on the news media. And then the task of vetting the nominee falls to the hands of the Senate Judiciary Committee. They'll conduct hearings, interview witnesses, gather evidence and information about the nominee's background, education, training, experience. If he has any experience on the court as a judge, perhaps as a state court judge, he could be or she could be a law school professor, could be just a lawyer that has a great reputation and has been somehow involved in politics. There's a variety of different ways to get the attention of the senators and to make it through this process. But even once you've been nominated, you're going to be investigated over and over and over. And it'll end with this investigation by the Senate Judiciary Committee. And they'll hold these hearings and ask questions of the nominee. And oftentimes, if it's a Supreme Court nominee, those questions are being asked before a lot of journalists. People are watching to see how you answer questions. The questions, unfortunately, can get very political and partisan. And that's just because senators on the Judiciary Committee are, in fact, politicians. And so they are looking to see whether the nominee, their decisions or their opinions match the political ideology of the members of the committee. So they're asking questions really designed to see how the judge would rule on a particular situation that implicates public policy. And that's how public policy or politics finds its way into this process of selecting judges. So if you're electing a judge, politics is obviously there because the judge has to run for the position in campaigns. But even when it's not an election, even in this appointment process, politics has made its way in because the Senate and the president are looking at the judges and trying to figure out if the judges' decisions would fit a particular political ideology. This hyperlink here, I'm going to show you. It takes you to a particular website here that presents what some political scientists, Martin and Quinn, these are two political scientists that work in the University of Chicago, and they've developed a way of analyzing the decisions of U.S. Supreme Court judges. So this is just a look at the Supreme Court, not all federal judges. And they have analyzed the decisions and how those decisions might fit on a political, ideological spectrum. And you see that they've determined that there are 3 U.S. Supreme Court judges whose decisions tend to fit with a political ideology we might define as liberal. And then there are 6 U.S. Supreme Court judges whose decisions might fit with a conservative political ideology. And you are able to match that with the political party of the president who nominated them. That's why you see the blue and the red. Justice Sotomayor, Justice Kagan, and Justice Jackson were all nominated by a Democratic president. And then the other 6 justices there, Alito, Thomas, Gorsuch, Barrett, and Kavanaugh, and Roberts, were all nominated by Republican presidents. And so what we're seeing here is evidence of that political influence on the judicial branch, because they are clearly here choosing judges whose decisions and judicial philosophies yield opinions that sort of fit in a certain place on the political spectrum. Now, this is not to suggest in any way, please don't misinterpret me, This is not suggesting that these judges themselves are political partisans. I do not mean to suggest that at all, and I don't even think that. Personally, I don't think that's what they're doing because there are judicial interpretive philosophies that judges adopt over the course of their career, and those philosophies just tend to yield certain results that Democrats may like, or Republicans may like or not like. And it isn't that they're trying to play politics, it's just the way they view the law, the way they interpret the Constitution. And they're valid either way. It's not like they're making things up. They're relying on precedent and valid practices. It's just the result makes one side happy or another side happy. And so you just get this sort of result when you start studying their decisions, as Martin and Quinn did. Um, but back to the process. So after the Senate Judiciary Committee does its vetting process, the decision to confirm or not confirm a nominee falls to the full Senate, and you need a majority vote. So there's 100 senators. You only need 51 senators who confirm or not confirm a justice. You get 51 on board, then the justice or judge, because this applies even to federal district judges or circuit court judges, they'll be confirmed and they'll take their seat on the bench. So it's a long, long and arduous process. And through that process, you wind up with a problem. I mentioned before that federal judges are not elected, and that's unique to the judicial branch. The president's elected. That's an elected position. Members of Congress, they're elected. It's an elected position, right? So that's democracy. They're democratically elected members of the executive branch and the judicial branch. But we don't elect judges. So they aren't directly accountable to the people. Rather, they're indirectly accountable to the people because they are appointed by the executive and legislative branches. So what that does is instead of making judges directly accountable or dependent upon the people, they are instead dependent upon the other two branches of government. And that's a violation of the separation of powers because the whole point of the separation of powers is to yield an independence of the three branches, to make them on equal footing. They each are co-equal branches of government. They're supposed to each have their own independent realm, their work that they do, and that they're not any more or less powerful than any other branch of government. That's the design. They all have the same power. They all have the same strength. They're on equal footing, all three branches, same level. But when you make it so judges are selected by the other two branches, then you make those judges dependent on the other two branches to get their job. They're dependent on the favor of the other two branches to be chosen. So they have to have favor of the president. They have to have the favor of the Senate to get their job, and creates a dependency there. And that's a problem. They're not fully independent of the other two branches. However, we get that dependence we get the independence restored when you come to the tenure. So how long do federal judges serve? The Constitution, Article 3, sets the term. Article 3 reads, the judges, both of the Supreme Court and the inferior courts, so that would be the lower courts that Congress forms, shall hold their offices during good behavior and shall receive compensation which shall not be diminished during their continuance in office. So what this means is that once nominated and confirmed, once they've been appointed and they're on the bench, federal judges can't be fired for purely political reasons. That restores the independence of the branch. The president can't fire a judge just because the judge issues a ruling that the president doesn't like, politically doesn't like. The judges, the members of Congress cannot remove a federal court judge just because Congress does not like the judge's ruling. It's job security, essentially, that restores the independence of the judicial branch. It gives the judges and the justices of the Supreme Court the freedom to interpret the Constitution and not be concerned about politics. So you take politics out of it when you give them the ability to serve for good behavior, give them that job security. They don't have to worry about pleasing the president or pleasing the members of Congress and giving them the rulings that they want. They can act independently, interpret the Constitution the way they think is legally sound, and not worry about whether it is politically favored by the particular president who happens to be in office at that time. They're not catering to the politics of the day. They're looking at the law and applying it consistently over history, regardless of the politics inherent in the other two branches of government. So independence restored, thankfully, by the tenure that gives them that job security. Don't assume, however, that it is lifetime tenure. That is not guaranteed. Judges often retire once they get to older age. They don't want to be on the bench forever. They have grandchildren they want to go spend time with, and they have lives they want to lead just like the rest of us. They want to enjoy their retirement. So they often retire once they get to a certain age and enjoy some break. Judges can also be impeached. They are federal judges are considered officers of the federal government, and so they can be impeached the same way the president can be impeached, or the way a member of any member of the executive branch can be impeached by Congress. So if Congress decides that a judge is violating the Constitution in some way or is corrupt in some way, the Congress can impeach a judge and remove them from the bench. And don't be fooled, this does happen. It has happened many times where a federal judge has been impeached, and it's often been for financial corruption, unethical behavior. That's the most often the reason a judge is impeached is because they've behaved unethically or in a corrupt fashion. So judges can and have been impeached. The judges can and often do retire when they get to a certain age. On top of that, I mentioned that the judges are members of the bar, and the bar associations have an ethics advisory council and officers who are scrutinizing the behavior of judges. They are looking to see that judges are behaving in an ethical fashion, that they are demonstrating competence. They aren't demonstrating any sort of mental disability, dementia. They are looking at that. They're looking if they are having problems with their mental competence and ability to make reliable and valid rulings on the law. So that they are not beyond scrutiny, is my point. The judges continue to be scrutinized. Even U.S. Supreme Court justices are being scrutinized by their peers. And judges often, especially appellate judges, they don't make their rulings alone. They are working on panels. Like there are 9 Supreme Court justices who make rulings, and you must have a majority of them. On the circuit courts, there's at least 3 making a decision, and you have to have a majority of that circuit court panel to make a binding decision. So their chance of there being a rogue federal judge is nil. It just doesn't happen because they don't rule alone. And they're held accountable to their peers. They're held accountable to the bar. They're accountable to Congress. They're accountable to the president. So now we shift over to the powers of the judicial branch. So this is a new topic. Remember the principle of limited government? That's going to play a role here as far as defining the powers of the judicial branch. The Constitution, we have a written Constitution that limits the power of the judicial branch because it enumerates the jurisdiction of the courts. We know that the job of the judicial branch is to interpret the law. The president, so the Congress makes the law, executive branch enforces the law, judicial branch interprets the law. Okay, so that's their general power. But the interpretation of the law is in the context of dispute resolution. So you're always going to have a dispute. Some people are arguing over the meaning of something. They're arguing over the power of a government, or they're claiming money from another party who's wronged them. There's going to be some sort of dispute. And it is that dispute that gives the court the opportunity to interpret the law. So before a judge can ever go about the business of interpreting law, there must be a dispute over the law's meaning. So that's how a case is going to get there. Dispute comes first, gives the court the opportunity to interpret the law. And then the law will be applied to a set of facts in order to resolve the dispute. So the dispute will involve it'll be a factual dispute. Something has happened, and the court's going to interpret and apply the law to that dispute and arrive at a judgment. And so that ability, the power to hear and decide a dispute, is where federalism comes in. It's where the jurisdiction or the powers of the judicial branch are limited. They're limited first in the type of dispute that they can hear and decide. There is a section in Article 3 that specifically defines the type of disputes that federal courts can hear and decide. And that limitation on the type of the dispute is called subject matter jurisdiction. So it's a specific form of jurisdiction known as subject matter jurisdiction. And the type of disputes that a federal court can resolve is laid out in Section 2. There's only two particular types that I want you to learn. One is federal question jurisdiction, and the other is diversity jurisdiction. So let me explain that. Article 3 gives federal courts the power to hear and decide disputes that arise under federal law. So that's why I have the quote there, arising under. When a dispute arises under a federal statute, so a law Congress has enacted, or if it arises under some dispute involving the Constitution, then there's a federal question in that dispute, and a federal court can resolve it. Diversity means the diversity of the citizenship of the parties before the court. So a citizen of one state is bringing a lawsuit against a citizen of another state, and that lawsuit involves a threshold amount in controversy, some financial sum that exceeds, and today it's $75,000. That's the financial threshold. So citizens of different states suing each other, and they're claiming an amount in controversy that exceeds $75,000. So if you have that federal question jurisdiction or diversity jurisdiction, then you can file your lawsuit in the federal court system. So now we're going to look at the hierarchy of the federal court system and a new type of jurisdiction known as hierarchical jurisdiction. So we've done subject matter, now we're doing hierarchical jurisdiction. Here's our pyramid again, so you can see the structure as I'm talking about hierarchy. The bottom of this pyramid in the federal court system are where the U.S. District Court sits. Currently, there are 94 U.S. District Courts. These are all formed by Congress. Remember, these are the inferior courts that Congress had the power to form. And they are the courts of original jurisdiction, where cases originate. So if you want to file a case, the initial dispute, you want to bring it before U.S. District Court, you're going to bring it to a U.S. District Court right here. That's the court of original jurisdiction. And you'll wind up in something like this, a courtroom, because district courts are set up this way. In a district court, you're going to have a jury. You'll have the parties each sitting on one side here of the courtroom. Lawyers are going to present evidence, and the jury's going to look at that evidence, and the juries decide the case. You have a court reporter here. She's writing down, well, actually typing, everything that is being said. She's going to receive the evidence and mark it, make it a matter of the court record. And here's, witnesses who are testifying, or here the clerk for the judge. He's going to assist the judge. And so what does the judge do, a district court judge? Well, he's the referee. He's the person who's going to sort of control the process of a trial. The judge himself or herself doesn't make the ruling. The jury makes the ruling. So they hear the evidence and they decide who wins or who loses. They make these evidentiary determinations, these factual determinations. The job of the judge is to make legal decisions. So that would have to do with the application and interpretation of the law. The jury applies the facts and decides, do they believe this side or do they believe the evidence of this side? So they're making factual determinations, and then they take the law that the judge gives them and they apply that law to the facts and decide who wins the case. That's how a trial court works. That's another word for it. The courts of original jurisdiction are known as trial courts because it's where the trials happen. And we refer to them as district courts in the federal court system. The decisions of a district court will only bind the parties to a specific case. So the plaintiff or the defendant in a civil case is what the parties are called. If it's a criminal case, it would be the criminal defendant being prosecuted by a U.S. attorney. So the U.S. government is the other party there. But only the parties are bound by the decision of a U.S. district court. And keep in mind that the factual decisions are made by a jury, the legal decisions made by the judge. The loser of a district court decision has a right to appeal to an appellate court, and that in the federal court system is known as the U.S. Court of Appeal or the circuit courts. There are 13 U.S. circuit courts across the United States of America, and that's where the appeals from district court decisions are brought. When you go to a circuit court, you're going to be before a panel of judges here. So it's more than one judge. There is no jury. And that means they are not making any factual decisions at all. The appellate courts are only going to look at the potential for legal error made by the judge. They are not looking at factual error by the jury. The jury decides the credibility of the witnesses and the evidence, but they can evaluate what the federal district judge does. The decisions that that judge makes are reviewed by this panel of judges that sit on the appellate court. So they evaluate the record that the court reporter makes of the trial, and they look at what the legal decisions were, and they can either affirm the district judge or reverse the district judge's ruling. And that's what appellate judges do. They hear appeals from the lower court. This panel of judges, their decisions bind the lower courts. So you're always moving down the pyramid. The decisions of circuit courts can only bind the decisions of district courts. So no longer is it just the parties. It's actually of the courts. So a decision of the U.S. Circuit Court becomes the precedent that binds the district courts. So let's look at what precedent is then. A precedent is defined as a ruling or a decision that others are bound to follow. And the precedent, the ability to set a precedent depends on where the court sits in this hierarchy. So that's what hierarchical jurisdiction means, the power to bind other people, to bind other courts. And depending on where the court sits in this hierarchy, that's going to determine the power of the court to bind others. So a circuit court can bind the district courts. The U.S. Supreme Court binds the circuit courts and the district courts. Those decisions are always top down, as I said, but they can be persuasive. So one U.S. district court can persuade another U.S. district court. They cannot bind another U.S. district court, but they can persuade them. The U.S. circuit courts can bind U.S. district courts, but they can persuade other circuit courts. So it's persuasive going across the circuit courts, across the pyramid, binding going down the pyramid. Since the U.S. Supreme Court sits at the top, it binds everybody in the United States of America. Courts do not like to overrule precedent, and that's an important aspect of the judicial power. This is known as stare decisis. It's a Latin phrase that means let the decision stand. Courts are reluctant to change their rulings over time. If the courts were constantly changing their decisions, there'd be no predictability in our civic life, and it would be impossible to have an orderly and just society if the courts can just change their minds on a whim. So instead of changing their minds on a whim, they make rulings. Those rulings become precedent, they bind others, and they last potentially forever. There are only very limited circumstances when a court will overrule a prior decision and reverse themselves. That just doesn't happen very often because it creates too much instability in society. All right, the last type of jurisdiction for you to consider is geographic. And I don't really have a slide on this because it's too obvious. When we're talking about geographic jurisdiction, we're talking about geography. And that's why you've got a map in front of you. The geographic jurisdiction of the United States Supreme Court is the United States of America. It covers everywhere. The U.S. Supreme Court can hear appeals everywhere, from everywhere in the United States. The circuit courts have a more limited geographic territory, and that's defined by the colors on this map. So there's 13 circuit courts, and as you can see, they have this color-coordinated geographic jurisdiction. Here we are, South Carolina. We are in the geographic jurisdiction of the Fourth Circuit. So the decisions of the Fourth Circuit Court of Appeals binds all the federal district courts in these 4 states: West Virginia, Virginia, North Carolina, and South Carolina. Now, a decision of the Fourth Circuit, it can persuade the 10th Circuit or the 8th Circuit or the 5th Circuit, but it cannot bind them. It can only bind within its circuit. So the decisions of a district court, federal district court in South Carolina, will only bind the parties. But a decision of the Fourth Circuit binds the district courts in South Carolina, it binds the district courts in North Carolina, and it binds and so on and so forth. So it's going to bind all the federal district courts that sit in these 4 states. And then the district courts, as I said, only bind the parties. Most of the time, the geographic territory of a district is the political boundary of the state. But some states, as you can see, are kind of carved up a little bit more into northern, middle, and southern, such as the case in Alabama and Georgia and Mississippi and Florida. You see that there. So sometimes the district courts have a even more limited geographic jurisdiction. But in South Carolina, it's statewide. Okay, now let's look at the separation of powers. That has a big role in the workings of the judicial branch. Sometimes disputes that come before the federal courts involve the powers of the other 2 branches of government. And then that means it's going to involve the interpretation of a federal law. So that could be interpretation of the Constitution, or it can be an interpretation of a federal statute. And so you've got 3 branches of government. They all are on equal footing. No branch is more powerful than another branch of the federal the federal system. So that's what separation of powers is. They're all on equal footing, but they check and balance one another. So to keep one branch from going beyond their constitutional powers, to hold them in check, then one branch can sort of overrule the activities of another branch. That's checks and balances. That's how we keep one branch of government from becoming too powerful. All right. So what I'm going to discuss here then is how checks and balances work with the judicial branch. And one way they do that is by determining whether another branch of government has violated its constitutional powers or somehow exceeded its constitutional powers. That process of determining whether a co-equal branch of government has exceeded its powers is known as the process of judicial review. And so what I'm going to do now is show you a little video that describes the Supreme Court case that set up the power of judicial review, or first recognize this power of judicial review. So the speakers in this video are going to first describe the facts, that underlie the decision. Remember, the court never gets the chance to interpret the law until there is a dispute. So you had to have two people in a dispute, in an argument with one another. That argument was between William Marbury and James Madison. Yes, that James Madison, President of the United States, fourth President of the United States. At the time, he wasn't president. He was Secretary of State. And I think he was William Marbury. He was supposed to be appointed to the bench as a federal judge, but he didn't get his appointment. And I'll let them explain the facts. But just that's what they're going to start out. They're going to tell you the dispute comes first. So they're going to tell you what the dispute was. And then they're going to tell you how the U.S. Supreme Court resolved that dispute. And they resolved it by interpreting a federal statute. One of the Judiciary Acts that I mentioned earlier in this lecture, that Judiciary Act was passed by Congress shortly after the Constitution was ratified. And in that Judiciary Act, they gave the U.S. Supreme Court an additional power, one that the Constitution did not provide. They added to the powers of the U.S. Supreme Court. And that was the power to issue a writ of mandamus. And a writ of mandamus is like an order of the court, an order telling another person to do something. And so that's what was being interpreted, is whether Congress actually had the power to enlarge the jurisdiction of the U.S. Supreme Court. So it's sort of a complicated decision, but I think these guys do a good job of explaining it. So I'm going to play that now.
It goes back to the election of 1800 when Thomas Jefferson, the Democrat-Republicans, beat the Federalists of John Adams. And it's full of politics because Adams, on the last time he was in office, appointed these judges. And when Jefferson came in, he decided he didn't want those judges.
Back then, the inauguration, the change of administration, it didn't really happen until March. So you had this period where Congress was in session, but the president really hadn't changed.
In that 2 or 3 months, the Federalists and President Adams, who had just lost, they realized they're about to become the minority party for the first time ever. And both the executive and the legislative branches going to be dominated by their opponents.
So John Adams and his Federalist colleagues are trying to do whatever they can to stay in power. So one of the plans that they devise is to expand the number of judgeships in the federal judiciary.
Adams's thought in all this was, on the way out, I'm going to appoint a whole bunch of judges and they're going to carry on my legacy.
They passed a law that is nicknamed the Midnight Judges Act.
John Adams is literally signing judicial commissions,
nominating people, getting them confirmed by the Senate
into the waning hours of his presidency before Jefferson takes office.
And what's interesting about this is that John Marshall, who ultimately becomes Chief Justice of the Supreme Court as a part of this whole process, previously he is Secretary of State, and he's the one that physically has to deliver the commission to all of these new judges. But they ran out of time.
Whenever Thomas Jefferson comes into office, he realizes that there's all these undelivered judicial commissions for Federalist judges.
There's a stack of commissions on the desk, and Jefferson says, we don't want Federalists as judges.
And he orders his Secretary of State, James Madison, to not deliver them.
It's really a political decision that Jefferson resented the Federalists. He thought there were too many Federalists in the judiciary, and so he wouldn't deliver these appointments.
Well, one of these judges was Marbury.
It just so happened that Marbury had a friend who was the former Attorney General for the United States. And his friend said, well, there was a statute passed several years prior that allowed the Supreme Court the authority to issue something called a writ of mandamus.
A writ of mandamus. It's basically a mandate. So Congress said, if need be, Supreme Court, you can mandate that something happen. So Marbury says, I know. I'll ask the Supreme Court for a writ of mandamus to give me the commission as a federal judge.
Now, there's a lot of irony in this because John Marshall, who was the Supreme Court Chief Justice, was also in charge of delivering the appointments.
John Marshall, who had wanted to deliver the commission to Marbury in the first place and just ran out of time.
So John Marshall gets this request. He's like, ooh, I really want Marbury to get this commission. He's a Federalist. On the other hand, I have this new administration full of anti-Federalists, and I don't want to piss them off.
And as evidence for that belief, the Congress of the United States actually suspends the Supreme Court for a full year.
This was a signal to John Marshall and the other justices on the bench that if you decide this case in the wrong way against the Democratic Republicans, against the Jefferson administration, there are going to be dire consequences.
So John Marshall is faced with a dilemma.
If Marshall rules that Jefferson has to turn over the commissions, he's going to ignore the court order. Imagine that for a second. A president of the United States, a Secretary of State, ignoring an order from the United States Supreme Court. What precedent would that set? It would make the Supreme Court an inferior branch of the federal government.
And what's remarkable about this case is the way John Marshall sort of navigates this decision.
In Chief Justice John Marshall's opinion, he essentially poses three different questions. First, he wants to know whether or not there's some sort of legal harm suffered by William Marbury.
He says fundamentally that what the president did was illegal. By refusing to deliver the commission, President Jefferson did not faithfully execute the law.
Next, he wants to know whether there's a remedy at law for those legal injuries.
And Marshall says because Marbury didn't receive that commission, he has a right to sue. And so here we are now 2/3 of the way through the opinion, and it looks like Marbury's about to win.
Then we get to that third question. Can the Supreme Court do anything about it?
And Marshall turns around and basically does a 180-degree turn and says, but we have a problem.
He decides to go back to the Judiciary Act of 1789. And he finds that this writ of mandamus was an expansion of original jurisdiction. It expanded the power that the court has under the Constitution.
What would happen if we could add to the court's original jurisdiction outlined in the Constitution just by passing legislation? Well, that means that you could amend the Constitution with any old act of legislation. Why not amend Article 1, the powers of Congress? Why not amend Article 2, powers of the presidency?
So what does Marshall do? He says, you know what? I don't think that part of the Judiciary Act of 1789 is constitutional.
Chief Justice John Marshall reasons that the Judiciary Act of 1789 essentially amends the Constitution.
The Supreme Court doesn't have the power to issue a mandate that something happen.
Therefore, the part of the Judiciary Act of 1789, that's Section 13, that adds to the Supreme Court's original jurisdiction must be null and void. It cannot stand because it directly conflicts with Article 3, Section 2 of the United States Constitution.
And as a result, he declared a law of Congress unconstitutional.
And from then on, established the precedent for judicial review.
Judicial review.
Judicial review.
Which is the court's greatest power. That only the Supreme Court can say what the Constitution is.
This ability to examine laws, compare them to the Constitution, and when there's a discrepancy, to actually declare that law or part of that law null and void.
It is a seminal case that defines the power of the United States Supreme Court. The Supreme Court today has the power to interpret the Constitution and say what the law is solely because of Marbury versus Madison.
Okay, so now you understand why judicial review is so important. It is the way that the court system, the judicial branch, can check the power of the other two branches of government. We'll go next to more about checks and balances. We've already talked about how the executive branch appoints or nominates judges to the federal court system. That is a check on the power of the judicial branch. The Senate approves, does a lot of investigating and vetting, and then may ultimately confirm the nominee. So that gives the legislative branch a check on the judicial branch. The legislative branch also is going to be the source of constitutional amendments, and that is certainly a way that the legislative branch can check the power of the judicial branch. Let me give you an example that a notable example of when that actually happened. If you recall the U.S. Supreme Court decision that was released shortly before the Civil War, the Dred Scott decision, that was where a slave whose owner, I hate saying that, the slave's owner brought the slave to a free state, a state where slavery had been abolished, and they lived there for a time. So Dred Scott was that slave, and he brought a case in the federal court saying because he had lived in a free state, he was therefore free, and his owner should release him. And the U.S. Supreme Court ultimately heard that case and decided that the slave was not a citizen of the United States and therefore couldn't even bring the lawsuit in the first place. He had no standing to sue because he was not even a citizen of the United States. So horrible, horrible, unjust decision, but it was made by the U.S. Supreme Court. Fortunately, about 10 or 15 years later, Congress amended the Constitution. And when I say Congress did it, I don't want to mislead you. They proposed an amendment to the Constitution, the 14th Amendment to the Constitution, which was then ratified by the people of the United States. And the people therefore overruled Dred Scott through an amendment to the Constitution. The 14th Amendment defines citizenship in a way that includes all people enslaved, and free. Even though by the 14th Amendment there were no slaves, it had been abolished. It simply made clear that if you were born in the United States of America, you are a U.S. citizen. And so it invalidated the Dred Scott decision. And that was a check on the power of the U.S. Supreme Court. Their decisions can, in fact, be undone by an amendment to the Constitution. There's also an inherent weakness in the judicial branch, and this is known as the problem of judicial implementation. You'll be reading a Federalist Essay number 78, which I believe was written by Alexander Hamilton. And in that decision, he is trying to explain how the judicial branch is not too powerful. In fact, he calls them the least dangerous to our freedom. And the way he explains it is that that the judicial branch, the only power it has essentially is to issue a choice, to make a choice or to make a ruling, make a judgment. Those are his words. All it can do is issue judgment. It can't enforce it. It's just a paper. It's what some judges think. It's their decision, their judgment on the meaning of the law. The courts are dependent upon the other two branches to go along with their decision, to obey it. No one is going to make them. They choose to obey it because they're going to follow the principle of separation of powers and recognize that the judicial branch is a co-equal branch of government, so they'll obey those rulings. But the court itself can't make them obey. So they're dependent upon that cooperation. And there are times when, a couple of times in history, where the president did not obey a U.S. Supreme Court decision. And there are also times when state and local governments have not immediately complied with a U.S. Supreme Court decision. And a notable example is with the integration of public schools. The famous decision Brown versus Board of Education, where the U.S. Supreme Court said that the separate but equal policy was a violation of civil liberties and ordered the integration of public schools. So they issued that judgment directing all governors and public school superintendents to integrate, to allow African American students to attend their schools. But that integration didn't occur until over 10 years later after the decision because they just delayed it. Some mayors and governors and school superintendents shut down the public school system in defiance of the Supreme Court's decision. And there really wasn't anything the Supreme Court could do about it. What had to happen is the President of the United States stepped in. Eisenhower and then Johnson stepped in and ordered the National Guard to escort African American students into the schools to force compliance with the decision of the U.S. Supreme Court. Presidents, as I mentioned, presidents have at times obstructed and refused to obey a Supreme Court decision. Andrew Jackson did that with a ruling that involved the Indian Removal Act. Abraham Lincoln actually defied the U.S. Supreme Court when he issued an order suspending the writ of habeas corpus in the Confederacy. So a couple of times in history where that separation of powers has broken down. All right, so now federalism and the judicial branch. We'll look at that next. As you remember, that federalism is the division of power, the balance of power between the national and state governments. State courts existed before federal courts existed, and states have their own constitutions that establish their own court system. So you have state court systems structured by state law, and their structure looks very, very similar to our federal court system. State courts resolve the majority of all legal disputes because federal courts have limited subject matter jurisdiction, something I've already covered in this lecture. There are only certain types of cases, certain types of disputes that you can even bring in federal court. So most disputes, therefore, must go to a state court for resolution. But the structures of state courts are very similar to the federal court system. They also have that sort of pyramid hierarchy with a court of last resort, a Supreme Court. Here, this is just South Carolina, for example. Sitting under it are intermediate courts of appeal. We call the South Carolina Courts of Appeal. And then below the courts of appeal are the courts of original jurisdiction, which are these here beneath the South Carolina Courts of Appeal. So you see that same sort of pyramid structure going on in the state court system that we also have in the federal court system. So they're alike in that way. Excuse me. Because you have these two levels of government, each with their own court system, we have something called dual sovereignty in the court systems. So dual court systems, each court system having their own powers. And it works out this way. You have state courts here, where this is the courts of original jurisdiction, a right of appeal to an intermediate appellate court, and the court of last resort at the state level are state Supreme Courts. A similar thing here in the federal system, but they all answer to the U.S. Supreme Court. So the U.S. Supreme Court has authority because of the Supremacy Clause. When the U.S. Supreme Court issues a ruling regarding the interpretation of the Constitution, it's going to bind the courts beneath it. Now, state laws, that's what I've got here. State laws vary somewhat. So a state appellate court decision can only bind the courts in their state. They can't bind any other states. And they certainly can't bind the federal courts. The circuit court decisions, they cannot bind the state courts, right? So the The federal court decisions bind federal courts, state courts bind state court decisions in that specific state. Okay, it's just the U.S. Supreme Court that has any sort of hierarchical power over both systems. Yeah, so the U.S. Supreme Court decisions bind federal and state courts. But remember, it is still limited in its subject matter jurisdiction. The U.S. Supreme Court can only hear and decide those certain types of disputes that are laid out in the Constitution. Its power is very limited. Sometimes there is an overlap when both a state court and a federal court will have jurisdiction over the same dispute. So parties do have some choice in where to file their case, particularly if it's a situation where a citizen of one state suing a citizen of another state, and they have that amount in controversy. The parties could choose to be in the federal court system because the federal court would have subject matter jurisdiction, but they also could choose to be in the state courts. It's really up to them. And if they bring that that case in the federal court system, the federal court can apply state law. And state courts, they can apply federal law. So the law that applies is determined by the subject matter of the case, not by what system you're in. State courts can apply federal law. Federal courts can apply state law. Whether you go to one court or another will depend upon the jurisdiction of the federal courts, the limited jurisdiction of the federal courts, and then also just the choice of the parties. Okay, who works in the judicial branch? That's our next topic. Well, judges, obviously. There are approximately 1,700 judges in the federal court system. Only 9 of them are U.S. Supreme Court justices. So we have 8 associate justices and 1 chief justice. And there's a nice picture of the U.S. Supreme Court. This is, John Roberts. I'm sorry, for a moment, his name escaped me. John Roberts is the chief justice. He's not any more important than these other people here. He just happens to have that title, which gives him, unfortunately, administrative responsibilities and not any greater power. To say you're a chief justice just means you have more paperwork to do. So the other 8 associate justices have just as much power and weight to their rulings, but they all act together as one U.S. Supreme Court. But that's just 9 of the 1,700 judges that make up the U.S. Supreme Court. The judges of the federal court system have lots of law clerks. So these are the people, their staff, who help them compile information and research the law and sort of offer some guidance in the rulings that the courts will make, the judges will make. There are certain attorneys who actually are employed by the executive branch, but they work a lot with the judicial branch, and so we mention them now. The Attorney General of the United States is the chief law enforcement officer. The Attorney General works in the executive branch. This is the Attorney General Pam Bondi. She's the head of the Department of Justice, which is an executive department. But her job involves a lot of, because she's an attorney, it involves the judicial branch. And that's why we're mentioning her role now. And then there's the Solicitor General. This is him. I think his name is John Sauer, I think is his name, if I'm pronouncing it right. He's the Solicitor General. He represents the national government in all cases brought before the U.S. Supreme Court. So even though he's a member of the Department of Justice, he works in the executive branch, he's the attorney who represents the U.S. in all cases before the United States Supreme Court. So he plays a large role. He's involved with the workings of the judicial branch, even though he's not actually part of it. So you have the Attorney General, who's like the law enforcement officer. So she's kind of in charge of all the prosecutions of criminal defendants in the federal criminal justice system. And then she advises the President of the United States in many ways. Then you have the Solicitor General, who represents the United States in cases before the U.S. Supreme Court. And the Solicitor General is also kind of a source of guidance for the Supreme Court. Sometimes they will consult the Solicitor General and ask the Solicitor General to file briefs in cases even where the U.S. Supreme Court's not, where the national government is not a party to a case. They may get the Solicitor General to file a brief. It's called an amicus curiae brief, friend of the court brief, to sort of give the opinion of the national government on a particular dispute. Okay, now we're going to talk for a minute about how a case gets before these people that we've just identified. How do cases get to the U.S. Supreme Court? When we were talking about the pyramid, the hierarchy of the federal court system, I mentioned about how to get to the district court, you're talking about someone just filing a lawsuit or a prosecutor is choosing to indict and prosecute a criminal defendant. So that's how you get before a district court. That's the initiation of a new lawsuit. The circuit courts of appeal, so those are just appeals from a district court. If you lose at the district court level, you have a right to appeal to the circuit court level. But when you get to the U.S. Supreme Court, in that situation, there is no absolute right to appeal to the U.S. Supreme Court. It is a petition that you must file first. It's a discretionary appeal. The U.S. Supreme Court doesn't have to hear your appeal. So what you must do is get their permission. So it's called a petition for writ of certiorari. You'll file a document, that's what it's called, a petition for writ of certiorari, and that is just a request to the U.S. Supreme Court to hear your case. You have to convince 4 U.S. Supreme Court justices to even hear the case. It's called the Rule of 4. And the Supreme Court will want to hear your case in certain specific situations. They're likely to grant a petition when the circuit courts are ruling on an issue inconsistently. Some circuits ruling one way, another circuit ruling another way, and there isn't any sort of consistency on a particular legal issue. And so the Supreme Court has an interest in resolving that inconsistency and coming up with one final ruling on the interpretation of the Constitution or an interpretation of a statute or an amendment. So if they're getting a petition to give us sort of the final say on something that is dividing the courts in the country, they're likely to accept those types of petitions. And that's just an example. There are a few other types of cases that they are more likely to hear than others. But you only convince 4. If you can convince 4 Supreme Court justices with your petition, they'll hear the case. And only then do they start looking at the merits of the case and decide who should win and who should lose the case. So if the 4 agree and your petition is accepted, the case is going to be placed on the Supreme Court's docket, which is essentially just a schedule. They'll schedule briefings, so they'll give each side of the dispute an opportunity to file a written brief explaining their position through legal arguments. On some occasions, they will include briefs from what you might call amicus curiae. That's a Latin phrase, friend of the court. So it's not just the parties to the dispute filing briefs. Sometimes other people are particularly interested in the outcome of a Supreme Court decision, so they will get the ability to write their own brief and submit it. I mentioned this earlier that sometimes the Solicitor General will file an amicus curiae brief by request. The Supreme Court will ask the Solicitor General, we want to know the national government's opinion on this particular legal issue, so you please file a brief as well. So they'll consider these written briefs by the parties and then sometimes by third parties, by amicus curiae. Friends of the court will just file briefs giving their opinions as well. On rare occasions, the U.S. Supreme Court will give oral argument on a case, and that's where the lawyers will actually come. This is the actual room here, the Supreme Court courtroom, and they'll make oral arguments before all 9 justices. There's a chair for each one there. And so they present their legal arguments through oral arguments, speaking it, not just writing it in a brief. After all the briefing and oral arguments are done, the U.S. Supreme Court will come together and essentially vote, cast votes on what the outcome of the case ought to be. But it'll be a little more than just a single one-sentence ruling. What the Supreme Court often does is write out very detailed opinions where they describe their reasons. They interpret the law plainly in a written way so that the public can read and understand why they ruled the way they ruled. And these Supreme Court decisions can be rather long, and there are different types of Supreme Court decisions. And so sorry, I didn't mean to do that. There are different types of Supreme Court decisions. For example, if a majority of the U.S. Supreme Court agrees on a ruling, then you'll get a majority opinion. And so it's 9 Supreme Court justices. A majority would be 5 justices or more. And if they all agree on the outcome, that outcome then binds everyone, because the Supreme Court is the highest authority in terms of the hierarchical jurisdiction of the court system. So if you get all 5 justices to agree on an issue, you have a binding decision, and they'll write out their reasons in a majority opinion, describing the reasons why. But if not all, so if it's not a unanimous decision of the Supreme Court, then you've got at least 4 or 3 or 2, just the ones who did not join the majority can write dissenting opinions. So dissent means disagree, and they'll explain why they dissent, why they disagree with the reasons or the outcome of the majority. Sometimes justices agree in the outcome, but not the reasons. So they'll provide their own reasons in a concurring opinion. Concur means to agree, but a concurring opinion may give different reasons why they support an outcome. And then every now and then, there is no majority. You don't have 5 justices who agree on the outcome. And so that result is a plurality decision, where it might be a split, 3 to 3 to 3, or 4 to 2 to 3, and you don't have a majority. And in that situation, there may be 9 different opinions written, and they're just giving a plurality, sort of a explanation of all their opinions, but no central majority ruling. So it's not really binding on anyone when you have plurality opinions written. In order to get a binding decision from the U.S. Supreme Court, you must have at least 5 justices who agree on the outcome. And then that decision will bind all federal courts and all state courts. How do judges make their decisions? That's what we'll look at next here. The first thing that comes to mind to you is probably, well, obviously they're using their legal knowledge and they're interpreting precedent. And yes, that is absolutely correct. That is, on what basis do judges make their decisions? They are going to look at the precedent. So these were what I defined earlier in the learning the lecture. These are the rulings of the U.S. Supreme Court, rulings of the circuit courts from the past. So how have they decided this particular legal issue in the past? That becomes the precedent that will guide decisions in the future regarding the same issue. Remember the principle stare decisis. Even the U.S. Supreme Court, circuit courts are reluctant to overturn prior decisions made by the same court. That's stare decisis. So rather than overrule themselves, they'll use prior rulings, those precedents, and apply them moving forward. So of course they're using their knowledge what they learned in law school, what they learned from experience, how they've studied the law, interpreted law, they're applying it to the facts of the dispute and arriving at an outcome. There is a lot of accusations that have been and will continue to be lodged against particularly the U.S. Supreme Court, but also other federal judges as well, that they are simply they're making their decisions based on politics, that they have partisan political beliefs. They just are going to issue rulings that align with the Democratic Party or the Republican Party one way or the other. That is not the case, and I think there's plenty of evidence to show that. And I've just put a quote up there from Chief Justice John Roberts. When they get together in conference to try to rule on the outcome of a decision, they are not aligning politically. Instead, they are looking at the law and they are applying it in the way that they think is correct. So let's look at that a little bit more. There is a area of study that looks at judicial decision making, and it's called legal realism. Sometimes it can be rather critical of the judicial decision making process, but really it's just a mode of analysis. So they look at how judges make their decision, and they find that there are other influences aside from just precedent. Judges will adopt interpretive philosophies, and this is particularly true when we're talking about the U.S. Constitution. They'll look at the Constitution and they can see it as something that should be interpreted in light of like the modern meaning that would be given to a term or to a phrase in the Constitution. What does this mean to us today when we use these particular words? That's called, that philosophy is called the living Constitution philosophy, where they're looking at the Constitution in the light of modern day meaning. Then there's another philosophy called the dead Constitution, where they're only going to give the Constitution the meaning it had when it was written. So if you're talking about the original Constitution, they're looking the meaning it would have in 1789 when it was ratified. If it's an amendment, they're going to look at when was that amendment ratified? What did those words mean then? And so it's kind of limiting the meaning of the Constitution to its historical context. So that's kind of a dichotomy then, different ways of interpreting the meaning of the Constitution. And different judges can have different philosophies about how to do that, and that philosophy then will influence their decision making. I put a quote up here from one of the former justices of the Supreme Court, Justice Antonin Kennedy, and he said, an activist court is a court that makes a decision you don't like. And that's because particularly the U.S. Supreme Court gets criticized for exercising judicial activism as if they're, political pundits going out, pulling the strings for political parties. And that is not the case. That is not what is happening. It's really just that the justices are applying different interpretive philosophies. How do we want to use the Constitution? Do we want to see it as a dead historical document, or do we want to look at it in the light of modern technology, modern interpretations, modern values? I'll give you an example of this, and that has to do with the death penalty. In particular, we have the phrase of the Eighth Amendment to the Constitution, cruel and unusual punishment. Well, what does cruel and unusual punishment mean? Well, that's going to depend on society, on our values. What do people believe today is cruel and unusual? That might be pretty different than what people believe was cruel and unusual 250 years ago. There's new technology that affects how we punish criminals in our society. A lot has changed. And so there's a U.S. Supreme Court decision that says we will interpret the meaning of this phrase according to evolving standards of decency. So we look at what does society today consider cruel and unusual, and allow that to guide how we might consider a particular form of execution or a particular sentence, whether it would be a violation of the Eighth Amendment or not. And so that's just an example of how interpretive philosophies can influence. Also, the U.S. Supreme Court is certainly aware of public opinion. They see protesters on the streets, and they know that the outcome of their decision is going to affect the public in some way. And that may be influencing their choices. And you can see, if you study the variety of decisions that have come down on one single issue, you might see some changes, such as abortion. We've seen that that change over the course of time. That was where stare decisis was not followed, and Roe versus Wade was overturned. This is just, I'm sort of poking fun at the situation with that little comic there, how sometimes time changes, or time has an effect on the decisions of the Supreme Court. Another example you might see in the case of these two U.S. Supreme Court decisions, this involves bans on homosexual activity. I'm not going to go into that in this lecture because it's getting to be kind of a long lecture. So I want to move on, just making you aware of the fact that the Supreme Court is aware of public opinion, and it might play an influence. The personal history of judges, their education, their experience, their life experience. There is some research to indicate that that is influencing the outcome of their decisions. And then there is some evidence that they're making strategic choices, that they're making decisions in a way to get other justices to agree with the outcome. So they're trying to form a majority, build a consensus on an ultimate outcome, in order to have a majority decision and not just a plurality decision. So there are other things that could be playing a role in addition to just the strict application of precedent. And so last we look at how the decisions of the federal courts can affect our civil liberties and our civil rights, and how they play a role in the judicial branch. And to understand that, we first have to look at the different types of law that exist in the United States. This is just a cursory overview of that. There is something called code law or statutory law. Those are laws that are enacted by a legislature. So it could be state legislature, or it could be our Congress, our national legislature. The laws that are enacted through the democratic process, how a bill becomes law, those are known as statutory law, regulations, or code law. There's also something called common law, which are rules established through dispute resolution. When parties file a case before a district court, or a court of original jurisdiction, they have a dispute, they bring their dispute before the court issues a decision, and then that ruling or the outcome of that dispute becomes a common law, a matter that applies in common throughout that court's geographic jurisdiction. And it is not established through the democratic process, it's just through that resolving that dispute, you've formed a precedent that becomes part of the common law of that jurisdiction. Constitutional law is a subset of common law. It is dispute resolution regarding the interpretation of the Constitution. So when a dispute involves the interpretation of the Constitution, the court, going all the way down to the district court, will make an initial ruling. It can be appealed. The circuit court gives its opinion that will be binding on throughout the circuit, or the U.S. Supreme Court may ultimately get it. And then that outcome of that dispute, as decided by the U.S. Supreme Court, that becomes an interpretation of the Constitution that binds all courts of the United States. So those are the different types of law. And now we'll tie in civil liberties and civil rights. Sometimes the dispute involves the exercise of government power against the right of individuals, whether it's through equality or just an individual liberty. So when a dispute resolution involves that balancing of power, government power against rights and freedom, then the outcome will affect the civil liberties and civil rights of individuals. And the Supreme Court doesn't take that lightly. No court takes that lightly. They recognize that in this way, the judicial branch has a lot of influence over how individuals conduct their lives in America. So they're very careful about making these rulings. And they'll apply rubrics or tests to guide them through these decisions to make sure they're striking an appropriate balance of government power against civil rights of equality and liberty. To understand that better, I will be one of your assignments in this class is to read a U.S. Supreme Court decision called Loving versus Virginia. This is sort of a famous U.S. Supreme Court decision. It was actually made into a movie, and it involves laws that banned interracial marriage. And I just kind of wanted to give you a little bit of a background so that when you go to do the assignment, I didn't want you to feel overwhelmed about it. This case involved a couple, Richard and Mildred Loving. Mr. Loving was white man, Mrs. Loving was black woman, and it was your typical two people meet, fall in love, they want to get married, but they lived in Virginia, and in Virginia, as did many states at the time, it was illegal for a white person to marry someone of another race. And that was particularly targeting African Americans, but it also would target, in some places, Native Americans, Asian Americans. So those types of laws were enacted in the 1920s all over the United States of America, kind of during a time where America was experiencing a lot of anti-immigration sentiment, Asian sentiment with a lot of Japanese Americans moving into the country. There was, unfortunately, a dark time in our country when people were very opposed to having immigrants come and become part of mainstream American society. And so state legislatures passed laws that forbid white people from marrying people outside their race. So clearly what you're going to be reading in this case is sensitive. They're going to use some language that might be offensive. Well, not might be, it is offensive, because they're going to refer to African Americans as colored people, which is something I even hate saying in this lecture, but I just wanted to make you aware that you might be reading things that are sensitive or uncomfortable. But the outcome, though, however, is good. And so what you'll see is the Supreme Court balancing the power of a state legislature to govern marriage, to regulate marriage, which is something state governments have always done. They've always been that's been within the powers of state governments to control marriage. And I don't want to say control, that's not really fair, but just to kind of provide the rules for how people get their marriage licenses, essentially. Those types of procedures of how you go before a justice of the peace or you go to get your marriage license. You would apply for one in a courthouse. State governments have always been in charged with regulating marriage, so that's not anything new. But it was the way they were regulating marriage in this case that became a problem. They were doing it in a very obviously racist, white supremacist way. And so that then brought in a civil liberties and civil rights issue. So the Supreme Court had to balance the power of state governments to regulate marriage against the right of African Americans and then the right of individuals to get to choose whom to marry. And so you'll see that sort of discussion in this case, and you'll see them apply a variety of rubrics or tests to those issues. And then you'll see the outcome, how they decided it, what their reasons were. And that's going to be a way for you to apply everything that I've lectured about in this video. It kind of runs the gamut of all you've learned about the judicial branch through that assignment. So if you have any questions, if you have a hard time understanding what the Supreme Court is writing about, please reach out to me, and I'll be happy to meet with you and to give you some more background and context for it. But that's the end of the lecture for today, and I would like you to proceed now to do your learning module assignments.